Hi everyone, and welcome to another Crim 210 lecture. For this week we're going to be looking at Canada's history of youth justice, and so we'll be talking primarily about 3 juvenile justice system acts. The first being the Juvenile Delinquents Act, which ran from 1908 to 1984. The second being the Young Offenders Act, which ran from 1984 to 2003. And third, the Youth Criminal Justice Act, which is our current piece of youth justice legislation that ran from 2003 until present. And I hope that this will be really helpful, especially for those of you who are interested in law school or who are especially interested in becoming Crown Counsel or defense lawyers, because this will give you a hint at how youth are processed through our justice system. And then especially for those who are more interested in the theory about why we punish youth or how we punish youth and what we think might be a good way of approaching youth justice or a poor way of approaching youth justice is through models of youth justice that essentially dictate different philosophies about how to approach dealing with youth that are in conflict with the law. Following this week's lecture, I'll be talking in subsequent lectures about policing youth, how we respond to youth in courts, and how we respond to youth in corrections. But before we get to that point, we need to actually understand how youth are processed through our juvenile justice system. We'll go through the history of youth justice in Canada, starting with the Juvenile Delinquents Act from 1908 to 1984. You don't need to memorize these dates, but you do need to know the order in which the different youth justice acts in Canada came in. So Juvenile Delinquents Act, then the YOA or the Young Offenders Act, and then the YCJA or the Youth Criminal Justice Act. So the motivation for bringing in the JDA was based on the idea that youth were frequently being detained with adults while awaiting trial. And remember from the child savers movement, this is why we brought in that historical perspective in week 2, the child savers movement wanted to make sure that youth were not being housed in the same facilities as adults, because these child savers believed that adults were the individuals who were responsible for corrupting youth. So there's this growing awareness that there were a number of poor children living on the streets and that they needed to be placed in those reform schools. So to model or to come up with a way to justify placing these individuals in these specific reformatories, we needed an actual legislation guiding the use of these reform schools. And again, this was especially because during the Industrial Revolution in Canada, we were seeing more wayward youth out on the street begging or gambling or engaging in prostitution, engaging in alcohol use, and there was a response to this perceived increase in youth crime. When a Justice System Act is enacted, there's always some sort of overarching philosophy. It's usually fairly coherent. It has one particular goal or multiple goals, all part of the overarching aim. The philosophy of the Juvenile Delinquents Act was really primarily based on the principle of parens patriae, which I think we introduced earlier in the semester. It basically refers to the idea that if the parent is unable to act as the caregiver to the child, then it is the responsibility of the state to assume the caregiving role for that child. So it's the idea that the state is father. The state can take on that paternalistic role. And I'm not saying that's a good thing, but I'm saying that this is the philosophy of the JDA at the time. Under this Juvenile Delinquents Act, there was a very humanistic belief, a very altruistic belief. I think people genuinely did want to see the lives of these youth improve, but I just don't know if they were going about it the right way. So they were targeting individuals who were coming from a poor family background, individuals that lacked maturity and were perceived to lack those middle-class Protestant values. And so the focus of the Juvenile Delinquents Act was to treat the youth and to treat their family, or if they could not treat the family, provide that youth with a surrogate family, whether it's through placement in a reform school or finding an adopted or foster home for that particular youth. The JDA came up with the idea that they were focused on the best interests of the youth. This raises a really important point, and one that lawyers were especially adamant about when they began to target and criticize the JDA. The idea of best interests can be very subjective. Is it the best interests of the youth? Or is it what the adult thinks is in the best interests of the youth? And very often these two things were in conflict. Is the youth wanting to go to a reform school, if it's not in the youth's own best interest, then it's not really true. In reality, under the JDA, it wasn't so much that people were thinking about what youth wanted. Instead, they were thinking about what they feel was the best scenario for these particular youth. Although treatment was a really big emphasis of the JDA, a major problem was that research had not yet evolved to a point at which we could rely on evidence-based practices to identify what types of treatment would be most appropriate. And this we'll see is a really dark and ugly history of Canada, where there were a lot of experimental treatment programs in correctional facilities. In Ontario in the 1950s and 1960s, they created these really radical experimental treatments that involved, for example, the belief that individuals incarcerated required a caregiving figure, and I'm not making this up, they actually strapped fake breasts to the walls of cells that allowed individuals to receive nutrients from this fake plastic breast. The idea here was to mimic what it would have been like as a child to experience that bond with the mother, so that maternal connection. This also included giving individuals LSD and then allowing individuals in a particular custody center unit to decide how one another would be punished. And this could involve the use of electric shocks. So there was really, really heinous intervention strategies with no basis in empirical evidence. And this is why the JDA might have been very unsuccessful in reducing the youth crime rate. It might have been well-intentioned about the idea, like, we need to provide services and treatment to these youth, but the research base had not yet evolved to a point where this intervention or these intervention strategies could actually be useful. Under the JDA, someone who's defined as a youth in conflict with the law would be a person between the ages of 8 to 16, where the upper bound varied by province. So in some places like BC or Quebec, it could be as old as 18. In a place like Saskatchewan, it could be as young as 15. Under the JDA, a very big component were status offenses to address the perceived immorality of youth. And a status offense is referring to a behavior for which an adult would not actually be punished for. For example, drinking alcohol, skipping school, engaging in incorrigibility, which is basically just not listening to parents. These were all behaviors that could actually bring youth into the formal youth justice system. Under the JDA, what was maybe a very forward-thinking principle was the idea that these were not offenders. These were just youth who were misguided and misdirected. So youth did not actually receive criminal sentences. They received dispositions. And this disposition was kind of like a doctor's report, but for an idea about what the causes of crime are for this young person and how to best intervene. During the JDA, Canada had that distinction between an indictable offense and a summary offense. An indictable offense being an offense for which an individual could receive 2 or more years in custody. All summary-based offenses would be dealt with in youth court, but even a 12-year-old, 14-year-old who had perpetrated an indictable offense could be processed through the adult court system. Here's a list of different dispositions under the JDA, and you don't need to memorize all of them, but it just is meant to give you a sense of how youth could be punished under this act. So sometimes there'd just be an adjournment or like a stay of proceedings where essentially there would be no actual outcome of the trial process or the adjudication process. A youth could incur a fine for as much as $10, which actually could be quite a fair amount of money back in that time, especially when we're thinking that these are young persons that are almost always brought into the JDA system because they're impoverished. It makes absolutely no sense to me why we would be fining people who are in poverty and are often committing crimes because they're in poverty. Wouldn't fining this individual actually simply increase the likelihood of them continuing to offend? Then we had more traditional adult type sentences, though again they were referred to as dispositions under the JDA. One would be a probation-based disposition. Another would be where the individual is sentenced to an industrial school or reformatory, so not quite like prison. The key here was that the disposition could be indeterminate. And I want you future lawyers to really think about what this means and the implications of this. Basically, what this sentence or disposition meant was that a youth could be held in a reformatory school until a probation officer said, "I believe that they have now been rehabilitated." So they could be placed in these reform schools up until about age 18 or age 21. It actually varied by province. It wasn't about the crime that they had committed. It was about the probation officer or the social worker's perception of whether the individual was making rehabilitative progress. And this had particularly detrimental impact on Indigenous youth. Because, for example, if they chose to speak their own language, this could be seen as an example of their failure to engage in rehabilitative processes. It's a really ugly mindset back in the day. But if they were not interested in practicing Christianity, they could be punished further for that, as basically a perception that they weren't willing to be rehabilitated. But really all they wanted to do was maintain their own culture, values, and beliefs. If a young person was age 14 or older, they could be transferred to adult court on the judge's discretion. Throughout Canada's history of youth justice, the most common type of disposition or sentence has been a probation disposition or sentence. Probation has been a very, very key feature of the Juvenile Delinquents Act, and probation officers held a lot of authority because, as I mentioned, they would kind of be the gatekeeper back into the community for the young person. They decided whether the individual seemed to have been rehabilitated or not. Judges could even dictate that the young person was to be placed in the custody of the probation officer, where the probation officer, again thinking about that principle of parens patriae, basically becomes an agent of the justice system, but also the youth's primary caregiver. And when you think about this, they're kind of being placed in conflictual roles, where the probation officer hat that they're wearing is maybe about punishing youth. On the other hand, the caregiver hat that the probation officer is wearing might be interested in looking out for the best interests of the youth. Again, that can be subjective, but how can the individual both be acting in the best interests of the justice system and in the best interests of the youth? What do you think actually happened? Do you think they acted in the best interests of the youth or in the best interests of their employer, aka the justice system? Probation officers and social workers also had kind of like carte blanche to go around and go to schools, go to the homes of these youth, interview parents, teachers, neighbors to gather information about the young person. This could be quite an invasive process of digging into this young person's past. And there are some major criticisms of the JDA, and the main one, which will be a common theme throughout Canada's youth justice system, is the perspective, and I agree with it, that there is a different avenue of justice for individuals that are white compared to individuals who are from a non-white minority status, so especially when we're talking about Black, Indigenous, and other persons of color. We saw a real high demand from probation officers and social workers to require youth to change their culture and change their beliefs. So what I mean by this is that for individuals under the justice system who are white, little progress was needed to be made to demonstrate rehabilitation. All they had to do was continue to abide by the cultural beliefs that maybe they had been taught all along. But if you were Chinese or Indigenous or Black, you might have had your own culture, your own values, and own beliefs. And maybe you wanted to hold on to those, and you could be punished for them when you were placed in custody or in a reform school and you didn't actually want to change. Alternatively, maybe these young persons did try to change and did try to adapt while they were in custody. And here's what's really sad is that could make them disconnect from their family when they return to the community. Indigenous youth, Chinese youth, Black youth, other youth might not want to do things like speak their own language while they're at home because maybe they don't want to remember the mistreatment that they received while they were in custody. So this unwillingness to speak their own language at home might create a disconnect between them and their parents or them and other siblings, especially if their parents do not speak English or English is just an additional language for them. To summarize, we could basically see one of two problems. The first would be that minority persons in these reform schools would refuse to adapt, and then they would perceive to be resistant to rehabilitation and thus required to stay for an indefinitely longer period of time. Or they would adapt, but this adaptation in custody would have detrimental effects when they moved out into the community in terms of severing bonds or diminishing bonds with friends, family, who maybe were maintaining or wanting to maintain this culture. So we see this sort of disconnect between family, friends, and the young person that was forced to adapt while incarcerated. In addition to these oppressive undertones of the JDA, another major attack on the JDA came from lawyers and judges, because one of the issues was that there was far too much judicial discretion. A judge had so much freedom to give a wide range of different dispositions, and it was often not so much based on the offense that the young person had committed, but the probation officer's report on the background of that young person. So the young person could be blamed not for what the crime was, but for what their history was, or what their parents' history was. And this is kind of ironic, because sort of like a fundamental principle of Christianity is that the sins of the father are not the sins of the son. That's kind of like a patriarchal reference, but the general idea is that the sins of the young person's family should not be the sins of the young person themselves. And this sort of principle was not adhered to under the JDA. It could result in the young person spending a longer period of time in these reform schools. Another major issue was the idea of status offenses, where the young person is essentially being punished for the behavior that would not be punished if it were engaged in by an adult. So this is sort of tantamount to cruel and unusual punishment. Another issue, which basically exacerbated the issue of judicial discretion, was the idea that across provinces, the maximum age at which somebody would fall under the youth justice system varied. The system in Canada is supposed to be fair for all Canadians, but if different provinces have these different rules, then the system might be perceived to be unjust. Another issue was that these reform schools were poorly funded, they were terrible conditions, and thus not necessarily very conducive to the rehabilitative experience of young persons in custody. Norway would be a great example of what an institution should look like, at least in my opinion. And my opinion isn't based on my politics or my ideology. My opinion is based on what we know about how to prevent crime from happening in the future. We know that specific deterrence is not particularly effective. If somebody is incarcerated, and I definitely do believe in incarceration for protection of the public, but while somebody is incarcerated, why wouldn't we want to help them become better persons, to provide them with the services they need to avoid involvement in criminal behavior in the future? Because even if you don't agree with giving these other persons services, wouldn't you agree with the idea that we should try and prevent people from experiencing victimization? The best way to prevent victimization is to improve the rehabilitative needs of persons in custody. Then shouldn't we be focusing on what their needs are, so that we can have them released into the community and they won't actually commit further harm and offend against future victims? Another big issue was that despite what the JDA was doing, it didn't seem to actually be having an influence on rehabilitating youth. Indeed, the crime rate in Canada was perceived to be on the rise. Unfortunately, this was tackled by trying to be more punitive when it came to adjudicating young persons. We will see whether it's the YOA, the JDA, the YCJA, a common criticism is that the law is simply not strict enough, that we need to be more punitive towards youth. And often this perspective is not based on what the youth crime rate is actually looking like or what the best response to youth crime actually is. Instead, it's more about ideology. To summarize the main criticisms of the JDA, first, it was relatively racist, though that wasn't necessarily a criticism of the JDA at the time. It's more, if we look back on the JDA, we can see some systemic racism intertwined into elements of the Act. The second main criticism was with respect to legal principles. So procedures, legal rights of youth were being violated, and so lawyers were very concerned about this. And then the third concern, or the third criticism, was that it was not punitive enough. The Juvenile Delinquents Act lasted for almost 80 years, 1908 to 1984. So what happened leading up to the 1980s that really made Canada change its mind about the Juvenile Delinquents Act? The first major change was in 1960 with Canada's Bill of Rights that introduced the idea that indeterminate sentences were generally wrong, that we should avoid these types of cruel and unusual punishment. And the main feature of the Juvenile Delinquents Act was that all youth would be given basically these indeterminate dispositions. For 20 some odd years, the Juvenile Delinquents Act was basically in violation of the principles of Canada's Bill of Rights. An even more important piece of legislation that came into effect in 1982 was Canada's Charter of Rights and Freedoms. It said things like everybody has the right to an attorney, everyone has the right to the best possible defense, everyone has the right to be free from cruel and unusual punishment. And these were a lot of principles that were not adhered to under the JDA. Youth would not be provided lawyers. They would often be told that they would be punished for asking for lawyers, or that it was going to cost them a lot of money, so they would be unrepresented, or at least underrepresented when they were in youth court. And judges had so much discretion. There was no real guiding case law or descriptions of what minimum and maximum sentences or dispositions should look like. And so the youth justice system under the JDA really treated young persons unfairly. The Young Offenders Act, or the YOA, was brought in as a response to the JDA, and the goal was to address those issues of not being strict enough. So they wanted to hold youth responsible in order to protect society. But they also tried to carry over some principles of the JDA, including that youth have unique needs that are distinct from the needs of adults, need to think more about treatment and rehabilitation. And also there was the belief that youth were more capable of being rehabilitated than adults. So there was some emphasis on how we should try and find community-based solutions to keep youth out of custody. Now, this was an emphasis of the YOA. This was a goal of the YOA, but it completely failed. To address the issues with violating youth rights, the YOA became much more focused on procedural rights, looking at legal rights and freedoms of the young person and making sure that these were maintained through all stages of the court process. One of the main concerns was proportionality in sentencing, and so this is where we began to see the dissolving of indeterminate sentences and the establishment of case law so that judges would be bound by certain past cases when handing down a particular sentence. What I have just discussed basically illustrates that the YOA was trying to emphasize a lot of things, and sometimes things that were in conflict with one another, things that weren't really in agreement. How do we emphasize protection of society and holding youth responsible, which were more kind of like crime control measures or punishing of youth, while also trying to say that we need community-based solutions? So on the one hand, some sections of the YOA are saying, hey, keep youth out of custody. On the other hand, other sections of the YOA are saying, hey, you need to punish youth and put them in custody in order to protect society. And so judges are kind of being given these discrepant principles and aren't really sure which one to prioritize. And so we're going to see some key issues with the YOA that resulted from this lack of hierarchy in principles or goals. On that note, some of the key goals of the YOA were, again, to hold young people more accountable, to provide greater protection to society, so protecting society from these young persons, and the need to minimize the impact of the justice system on young people, so thinking about labeling theories and how a young person's involvement in the justice system could further contribute to their continued offending. This was very much in line with the notion of state-dependent effects, which is If we, for example, incarcerate a young person, maybe that separates them from school, separates them from family or pro-social connections in the community. And when these bonds are severed, when they are released from custody, maybe they are going to be more likely to associate with delinquent peers rather than pro-social peer groups. Or now that they're out of school, they don't really feel connected to school or connected to teachers, so maybe they'll become more prone to skipping school or dropping out of school altogether. The YOA also wanted to protect the legal rights of the young person. So while they wanted to become more punitive, also wanted to make sure that the youth justice system looked like the adult justice system, and youth were always going to be represented by lawyers. One of the collateral consequences of trying to make the youth justice system look more like the adult justice system was that youth then became treated more like adults, meaning that they were punished more severely than they may have been punished in the past. Canada's general public began to look at youth not as young persons who had the capacity for rehabilitation, but rather serious and violent youth who were going to become tomorrow's serious and violent adults. So by making the youth justice system more formalized, it gave the public kind of this impression that, oh, these youth must therefore be very, very serious offenders, even if that might not have been the case. Is the judge supposed to focus on the rehabilitative needs of the youth, or protection of the public, or procedural justice? And so different judges could elect different principles or different goals depending on their own personal preferences or what they thought the personal preference of their employer was, aka the government. There were some major differences between the YOA and the JDA. One of them was that the minimum age of criminal responsibility was raised from 8 to age 12. They specified under the YOA maximum sentences, so they abolished indeterminate sentences. Under the YOA, they also established alternative measures. This was a way of trying to keep youth out of the formal justice system so they did not experience those labeling effects. So this meant diverting youth, keeping them out of the formal justice system and using these more community-based responses to youth crime. Under the YOA, there was a recognition that the young person should not be punished for status offenses, because this was essentially a charter violation. Essentially, it's kind of like cruel and unusual punishment. Youth are thought to be less responsible for their behavior compared to adults. So why is the justice system punishing youth for a behavior that an adult wouldn't even get punished for at all, let alone a less serious form of punishment? The JDA lasted for almost 80 years. The YOA didn't even last for 20 years. So there was a lot of opposition to the YOA. Canada's Reform Party and crime control advocates called for a lowering of the minimum age of criminal responsibility. They wanted it to go back to age 8 because they thought that there were these young super predators roaming the streets at 10, 11 years old, committing serious and violent offenses. As we talked about last week, this obviously wasn't the case, but that didn't stop the public and certain politicians from believing that this was the case. There was also the perspective that alternative measures were too costly. So what happened was the federal government instituted the YOA, but then told the provinces that they were responsible for funding alternative measures. So certain provinces, like Quebec especially, provided a lot of funding towards these alternative measures. Other provinces, like Saskatchewan and Manitoba, said, we're not going to fund these community-based measures. We're going to just rely on more crime control perspectives and incarcerate youth. And so we again see all these discrepancies across provinces. Police groups did not like the YOA because, number one, they felt that the procedures were too complex. Having to read young persons their rights in a way that the young person could understand was thought by police to be too burdensome. To me, it's like, too bad, so sad. You still have to do your job of reading a young person their rights. Their rights are just as important as adults, but policing groups did not see it this way. Policing groups also called for more punishment in the justice system. They said that this rehabilitative approach doesn't work. It's our turn. We're the punishment people. It's time to listen to us. 20 or 30 years ago, youth crime was really a hot button issue in politics and in sort of the eyes of the general public. There was all the questions about what do we do about rising youth crime rates? We don't see that as such a hot button issue maybe in the last 2 or 3 elections, because the youth crime rate is definitely on the decline. But back 20 or 30 years ago, there's a tendency, especially in the media, to sensationalize extreme cases. And one of them was actually in BC. It was the case of Jesse Cadman, who was severely attacked, and his father, Chuck Cadman, basically said that this is the result of Canada's justice system being soft on crime. I can absolutely emphasize that from a father's perspective, from a parent's perspective, it makes sense to want to have some retribution, to believe that we need to get tougher on crime. But the reality is also that these cases are kind of very atypical. And generally speaking, we don't want to build policies around atypical cases. We want to build policies around what is more common. Because if we build policies around atypical cases, they're not necessarily going to be effective in applying to the majority of cases that are not atypical, that are usually involving less serious offenses. So when we have these atypical cases, I'm not against responding punitively to them, but we have to understand that these are atypical cases, and we can't take the philosophy of punishment associated with these cases and apply them more broadly to all youth crime. The YOA was very frustrating for judges because they ultimately didn't know what their job was supposed to be. Was it to be protecting the public or rehabilitating the youth or following criminal justice system procedures? It all seemed kind of too speculative, too discretionary. To summarize, the YOA wanted to say that we need to hold youth responsible for their criminal behavior, but then on the other hand, the YOA was also saying, hold up, youth are less accountable for their criminal behavior than adults. So again, that caused confusion among judges. We see wide provincial disparities in the amount of youth being incarcerated. And when judges were faced with sort of this discretion of, do I focus on protecting the public or focus on the rehabilitative needs of the youth, judges erred on the side of protecting the public. And so under the YOA, Canada actually had the highest rate of incarceration of young persons among Western industrialized nations, including the United States. So think about that. In the 1990s, Canada was incarcerating youth at a higher rate than the United States. In response to the issues with the YOA underwent 3 major amendments. The first amendment was focusing on procedural changes. So you don't need to memorize all of these changes. You just need to understand the general theme here was procedural changes. So creating a uniform maximum age across provinces, that age would then be 17. We wanted to then also change the fact that youth were being detained with adults under the YOA. So they got rid of this. They made sure that youth were never detained with adults during pretrial detention. Pretrial detention, also known as remand, is when a young person, or really any person, is denied bail by a judge, and so they're placed in custody while awaiting the outcome of the trial and of their sentencing. These procedural amendments also mandated what we would call at the time predisposition reports. More recently, we call them pre-sentence reports. These predisposition reports was a report completed by a probation officer meant to describe the young person's background, who they are, whether they experienced trauma or victimization as a child, their substance use history, their family history, their mental health history, to try to give the judge a better picture of who this young person is, to try to eliminate some of the judicial discrepancies that we were seeing across provinces. The YOA also said that, okay, for serious offenses, we're going to try to facilitate an easier transfer of youth to adult court, basically by mandating that if a youth commits a particular type of offense, referred to as a presumptive offense, they will automatically be placed in an adult court system. These presumptive offenses refer to different types of homicide offenses, aggravated assault, and aggravated sexual assault. So the young person, if they had perpetrated or if they were accused of perpetrating one of these offenses, they would automatically be dealt with in adult court, and it would be the role of defense counsel to show on the balance of probabilities why the young person should not end up in adult court. Judges were also starting to become angry about the idea that they might place a youth on probation, and while on probation they committed a new offense, or they violated the conditions of their probation. In response, the YOA created a new offense, basically called a failure to comply. And what this meant is that if the young person violated the conditions of their probation, that could be used to justify their incarceration to serve out the remainder of their sentence. They would also be charged with a new offense called that failure to comply that could result in an additional custody sentence or an additional or lengthier probation sentence. The second and the third amendments to the YOA focused on getting tougher on crime, raising the maximum sentences for first and second degree murder, creating parole for youth transferred to adult court so that youth would actually be monitored upon release from adult court, as opposed to in the past youth would just finish their custody sentence and they would have no form of community supervision. So for youth committing serious offenses that have been transferred to adult court, once they're released, they are now under parole supervision requirements. As I mentioned in the past, there was that sort of discretionary issue with judges. Do they focus on rehabilitation or protection of the public? The Second Amendment said you absolutely focus on protection of the public when making decisions during transfer hearings. So if a youth was to be transferred to adult court, basically it would be because their offense was serious and they thought that the youth needed to be dealt with in the adult system where the punishment could be more severe so that the protection of the public could be accomplished. I'm not saying that that was actually successful as a way of protecting the public, but that was the thinking at the time. The third wave of amendments was again about getting even more tough on crime. The YOA further raised the maximum sentence for first degree murder and second degree murder. 16 and 17-year-olds involved in serious personal offenses would be automatically tried in adult court, and that reverse onus again was there, where the youth had to show on the balance of probabilities why the protection of the public would be better served if they were dealt with in youth court. And then victim impact statements were introduced to allow persons, not just the victim of the offense, but their family, to describe to the court how the offense negatively impacted themselves as a way to act as an aggravating circumstance against the young offender during their sentencing. Basically, this third wave of amendments was trying to increase sentence lengths and increase the feasibility or the ease at which youth were transferred to adult court. When I mentioned that they raised the maximum sentences, this was the maximum sentence if the youth was being processed under the Young Offenders Act. If the youth was transferred to adult court, then those 10 and 7-year maximum sentences went out the window and they could be given a life sentence, just like any person who was an adult. The YOA definitely did not solve the desire to get tougher on crime. Even after all of these amendments, there was still this perspective that the Liberal government was far too soft on crime, and that basically they needed to get rid of the Young Offenders Act and bring in an entirely different act. So even after these amendments, judges complained and law and order advocates complained of the lack of a hierarchy in the guiding principles. Do judges focus on rehabilitation and understanding that you should be held less accountable, or should they be punished more severely? One of the continued criticisms of the YOA was that youth crime rates were on the rise. So some people believe that this was evidence that we needed to get tougher on crime. The reality, however, was that the increase in crime rates was actually probably more a product of getting tougher on crime in the first place. The getting tough on crime approach meant that the justice system was now casting a wider net. More young persons were being brought into the justice system. In Ontario, for example, in the late to mid-1990s, they instituted zero-tolerance policies at school. Hey, teacher, leave them kids alone. So a fight at school would automatically result in a suspension, but also police were told to automatically arrest that young person. So in the past, these minor fights at school would go unpunished, but now that they're being formally prosecuted, or at least youth are formally being arrested, it now adds to the crime rate. So people are seeing this crime rate thinking that these are out of control youth super predators. But in reality, it's more like this was the same type of behavior that young persons were engaging in the past. They just weren't being punished for it. The public continued to have a very negative impression of the YOA, and like certain politicians, believed that it was too soft on crime. Those who really cared about procedural justice were saying that we are taking too many youth and placing them in pre-trial detention. Basically what's happening, and I'll talk more about this in future weeks, youth were being punished more punitively than adults when it came to the denial of bail. For example, a judge might look not just at the youth, but the youth's parents and say, I don't think that you are going to be living with a capable caregiver. I think that your parent is a gambler or lacks the ability to supervise or is perhaps an alcoholic. And because of this, I'm going to punish the young person for it, and I'm going to place them in pretrial detention so that they are away from the negative influence of their parent. This was especially true for young girls who maybe fled a negative home environment because they were experiencing physical abuse or sexual abuse. So they end up couch surfing with friends or living on the street, and they might engage in substance use or might become involved in the sex trade in order to support themselves. No young person should ever feel forced to engage in substance use as a means of survival. So I definitely get the idea we want to provide services to this young person, but incarcerating them might be fairly unfair. If a young person had committed a minor offense, they could be held in pretrial detention even if they couldn't actually receive a custody sentence for that minor offense. So it's more about protecting the young person from their negative social environment, which is something that we would never do under the adult justice system. After a short period of time, the Young Offenders Act was scrapped and the YCJ was brought into effect in 2003. There are definite problems with the YCJ, but this is, in my opinion, easily the strongest piece of youth justice legislation that Canada has had, because it's much more attuned to research, and it's much more attuned to the idea of creating a hierarchy of principles for judges, so that judges know when they should be most focused on rehabilitation, when they should be most focused on procedural justice, and when they should be most focused on punitiveness or most focused on a crime control perspective where youth are held responsible for their criminal behavior, and maybe punishment is given a greater level of emphasis. So the YCJ said we need a greater emphasis on crime prevention and we need to create meaningful consequences for youth. But they said, very, very importantly, the best way to prevent crime and the best way to protect the public is through the rehabilitation of the young person, not the punishment of the young person. If we want to protect the public, we need to rehabilitate this young person so that they don't commit crime in the future and bring further harm to victims. So to summarize, basically what the YCJ is saying as its rationale is that we need to focus on the long-term protection of the public. But the way that we can do this is through an emphasis on crime prevention that is done so through establishing meaningful consequences for the young person. And meaningful consequences doesn't mean being punitive. It means being proportional, matching the sentence severity to the severity of the crime perpetrated. And then when an individual is being sentenced, whether they're being sentenced to custody or whether they're being sentenced to probation, the goal of that custody sentence or of that probation sentence should be rehabilitation. So the three major principles of the Youth Criminal Justice Act are to prevent crime, to promote rehabilitation and reintegration, to provide meaningful consequences to the young person, And the YCGA said that if we can do these three things, this will promote the long-term protection of the public. What I want students to notice here is the complexity of the YCGA. It's taking principles from the JDA regarding rehabilitation and reintegration, but it's also recognizing what led to the downfall of the JDA, which was especially the inattention to procedural justice. So they're saying, hey, we need to have meaningful consequences. So there's those justice principles there. And then it's also recognizing some of those YOA requirements of we need to also hold young persons accountable. So what the YCGA said was that for the individuals that are perpetrating the most serious and violent crimes, they can either receive adult sentences or they'll be processed through the youth justice system fully and receive a youth sentence, but it will be of a similar length to an adult sentence. While this sounds complex, the key to the YCGA was that it said that the type of focus that the judge will have will depend on the nature of the crime perpetrated by the youth. So sometimes the YCGA is referred to as a triarchic model. What I mean by this is that it responds to three different types of scenarios and has three different ways of responding to these scenarios. So first, if the young person is involved in a non-serious offense, they should be diverted fully from the youth court system. If the young person has committed a moderate offense, they should be dealt with proportionally. We should recognize that their offense does not warrant incarceration, that their needs are best served in the community. Finally, for the individuals involved in the most serious and violent offenses, we should incarcerate such persons to protect the general public, but while such persons are incarcerated, the goal should not be punishment and deterrence. The goal should still be rehabilitation. One of the biggest issues that I think occurred under the YOA which was maybe the biggest violation of a young person's rights, charter rights, was the transferring of the young person to adult court, especially with those presumptive offenses that I mentioned. So if the youth had committed a serious personal offense, they would be automatically transferred to adult court, and while in adult court, they could then have their defense lawyer argue and have to show on the balance of probabilities that they would be better served in youth court. So it was this rebuttal principle of the YOA. And to me, it's crazy that lawyers didn't actually recognize this issue earlier. What is one of the most fundamental principles of our justice system? To me, I think it's the presumption that you are innocent until proven guilty. Under the YOA, presumptive offenses, and YCJ maintain these presumptive offenses, it's right there in the name. You are presumed to have committed a homicide offense. That's what justifies you going to adult court to be tried as an adult. But the whole purpose of the trial is fact-finding. Is the individual guilty or not? But individuals, the justification for placing them in adult court is the crime that they've been charged for. So it's almost like the youth is automatically being presumed that they've actually perpetrated this homicide offense or this aggravated assault. And so it was a real innate violation of the youth's charter rights. The YCJ initially somewhat addressed this and then later fully addressed it. So they somewhat addressed it by abolishing the transfer of youth to adult court. All youth under the YCJ were always processed under the youth justice system. However, if they had committed one of those presumptive offenses, then the Crown Counsel could initiate a proceeding to have the youth sentenced as an adult, and it would be the responsibility of the defense counsel to show on the balance of probability, so that rebuttal presumption, that the youth should actually be sentenced as a young person. To be clear, the YOA and the YCJ both had these presumptive offenses. However, initially under the YCJ, it's just that those presumptive offenses would be dealt with in youth court. Under the YOA, they would be dealt with in adult court. Under the YCJ later on, they eventually, through court cases in the Supreme Court, said, no, these presumptive offenses are unconstitutional and we're going to abolish them altogether. We'll still have the ability for Crown Counsel to have youth sentenced as an adult, but the onus will be on Crown Counsel to show on the balance of probabilities that the young person should be sentenced as an adult. I cannot emphasize this enough. There is no such thing as being tried as an adult under Canada's current youth justice system. When it came to youth involved in less serious crimes, like minor forms of delinquency, the goal was to deal with them outside of the formal justice system, through these multidisciplinary conferences involving key stakeholders or restorative justice system practitioners that could find ways to respond to individuals involved in minor offenses and individuals involved in first-time offenses in ways that could keep youth from being labeled while still holding them responsible for their behavior, so still having meaningful consequences established. The YOA basically said, oh, here are like alternative measures, go do them. And there was very little direction given to judges, very little direction given to police and to Crown Counsel. Under the YCGA, there was much more clarity about when these measures should be used. And so they created what are called extrajudicial measures and extrajudicial sanctions. Extrajudicial measures are a tool of the police. Basically, they say to police officers that you can, instead of formally arresting or charging, or in BC, because police don't charge youth, recommending charges to Crown, instead the police can simply issue a warning to a youth and or refer them to some form of community agency that can provide them with some assistance or some help. Very, very key. Under the YCJ, it basically directly talks to police officers, kind of looks right at them, breaks down that fourth wall and says, hey, these extrajudicial measures, you should presume them to be adequate for first-time individuals involved in non-serious offenses. Police officers are told that you should be using these extrajudicial measures. You're encouraged to use them, and here are the scenarios in which they should be used. And we're going to presume that they're actually adequate for all young persons. Extrajudicial sanctions, on the other hand, are more so the tool of Crown Counsel. And this is the idea about prosecutorial diversion, where maybe the Crown Counsel has charged the young person but believes that this young person is best dealt with outside of the formal processing in the court system. So we can still adjudicate the young person, but let's keep them out of the actual court system. And we can instead use restorative justice principles or have them engage in some form of restitution or community-based services. If the young person fails to abide by the agreement, so if they agree to fulfilling hours working in a soup kitchen, and they fail to carry out that community service, then they can have that extrajudicial sanction show up on their official criminal records, indicating that they failed to actually abide by the conditions of their extrajudicial sanction. Another thing that the YCJ tried to address, and ultimately they've been unsuccessful, in fact they might have even failed worse than the YOA, is in the attempt to address the overrepresentation of Indigenous persons. So directly in the YCJ principles, I'll just sort of read the quote here. It says that measures imposed on young offenders should respect gender, ethnic, cultural, and linguistic differences and respond to the needs of Aboriginal young persons and of young persons with special requirements. The language in this principle is a little bit outdated. We wouldn't refer to a young person as Aboriginal, we would refer to a young person as Indigenous, but the intent here was to remind judges to think about the backgrounds of Indigenous persons as a mitigating factor during sentencing because of the historical injustices that they've experienced, the genocide that their ancestors have experienced, and the systemic racism that they may experience living in Canada. The YCJ took this further in section 38(2)(d), which says, all available sanctions other than custody that are reasonable in the circumstances should be considered for all young persons with particular attention to the circumstances of Aboriginal young persons. This section of the YCJ is saying that, hey, we should always be thinking about alternatives to custody for all young persons, but just trying to nudge judges in the right direction, remind them, think about the circumstances of Indigenous youth and how that might have brought them under the formal justice system, and use that as a mitigating factor during sentencing. The YCJ also mandated GLADU reports, Remember when I talked about under the YOA predisposition reports? The YCGA said that every young person that is going to receive a sentence needs to also receive a pre-sentence report. That pre-sentence report is completed by the probation officer and will involve interviews with the youth. It will involve interviews with the family, school, mental health practitioners. It will include perhaps even a psychological assessment of the young person. And that pre-sentence report is delivered to the judge, and the judge uses that to help make their decision regarding sentencing. For all Indigenous youth in Canada, and for that matter, all Indigenous persons in Canada, are supposed to receive within their pre-sentence report a GLADU report. And the GLADU report is designed to recognize the specific cultural experiences of Indigenous persons in Canada, both historically and presently. And it was again meant to bring to judges' attention the idea that these circumstances should be used as mitigating factors at the time of sentencing. A GLADU report is called a GLADU report because of the case of R versus GLADU in 1999. And this has now created section 718(2)(e) of the Criminal Code that I just sort of will read off now. It talks about how Canada needs to consider the specific circumstances of Indigenous persons. GLADU reports should include a description of the youth's heritage, so their cultural background, customs, traditions, where their particular First Nations group may have originated from, provide a description of the systemic or background factors that might have involved the youth being brought into custody or brought into the court system, or contributed to the young person's offending, particular attention to things like poverty, substance use, and unemployment. Also needing to be attuned to the community and how we want to bring that youth back into the community to help resolve the harm that has been perpetrated. So thinking about sentences that are actually going to help be restorative. Another thing that I mentioned about the YCGA was that it's trying to basically avoid the YOA's over-reliance on incarceration of young persons. So remember when I was reading, I think it was section 38(2)(d) of the YCGA, it was basically saying that all judges need to consider all other possible sentences other than custody. The YCGA further helped address the sentencing disparities under the YOA by saying to judges, hey, guess what? You can only ever send a young person to custody if they meet one of 4 conditions. The 4 conditions in which a judge is allowed to sentence a youth to custody are if the youth has committed a violent offense, if a youth has a history of administrative offenses, so a history of violating court orders, if the young person has committed an indictable type of offense, and they have a history of prior findings of criminal behavior as well. And finally, if the young person has committed an indictable offense and there are particularly severe aggravating circumstances that go along with that offense, like if they perpetrated their assault against an elderly victim. Very importantly, just because the youth might meet one of these gateways, so just because they've, for example, committed a violent offense, doesn't mean that the judge must or even should sentence that young person to custody. It only means that they are then allowed to sentence that young person to custody. If the youth has committed a violent offense, the judge must actually consider whether all other alternatives to custody would be appropriate for establishing meaningful consequences. So you have to think about, would probation be useful, or would some form of other community-based sentence be useful in this particular case? I'll do a correctional lecture for this course, and we'll talk a little bit more about this, but another key point is that when a young person is sentenced to custody, they will actually only serve 2/3 of their custody sentence in custody. What will happen is, if a young person is, for example, sentenced to 6 months in custody, they would serve the first 4 months in a custody center, and then the last 2 months out in the community. And they call it, and it's so confusing, I hate this term, but they serve the remainder of their custody sentence, so 1/3 of their custody sentence, 2 months in this case, in the community. So it's a custody sentence served in the community, which is really confusing language. But what it means is that the young person will be, to help facilitate community reentry, they will be returned to the community after the 2/3 of their sentence is up. And while there, they are forced to abide by particular conditions that are meant to help with their rehabilitation and reintegration. If they violate those conditions, they are automatically placed back into custody for the remainder of their sentence, and then they can also be charged with a new failure to comply offense, and they can receive a further custody sentence or additional time spent in custody. Many concerns with the YCJ remain. It's really failed to address the overrepresentation of Indigenous youth in our justice system. There are still a lot of regional disparities, and I don't think this will ever change because ultimately the provinces are still responsible for administrating the youth justice system. And so different provinces will have different philosophies on how to respond to youth crime. Some will be more attuned to using rehabilitation, funding extrajudicial measures, funding extrajudicial sanctions, and others will be more preferring to use custody. We will never see this perspective go away, the perspective being that the youth criminal justice system is soft on crime. Like the YOA, the YCJA has also undergone several revisions. One of them came in the case of Archie Billard, who was a young person in Nova Scotia that had been released on bail, and while on bail, they had stolen a car, evaded police, and struck down a young woman who was crossing a crosswalk, and that young person died. And this understandably led to a lot of outrage in the general public about why was this young person released on bail to begin with? They should have been held on remand. So the Nunn Commission was enacted to review the procedures used by the Youth Criminal Justice Act and to reconsider the increased use of remand as a response to young persons that have committed certain crimes. Under the YCJ, violence was basically restricted to purposeful violence, and that meant that negligent behavior would not constitute a violent offense. So criminal negligence causing death was not thought of as a violent offense, which meant that it wouldn't really fit into that violent offense gateway talked about under the YCJ. In part due to the Nunn Commission, the YCJ introduced a few different revisions. Bill C-10 was basically trying to expand the definition of violence and bring back notions of general deterrence. Under the YCJ, Supreme Court of Canada cases determined that judges could not use general deterrence as a sentencing philosophy. Bill C-10 also wanted to see, however, that more young persons would be sentenced as an adult. Especially in response to the Nunn Commission, Bill C-25 said, "We want to see truth in sentencing. We want to expand the use of pretrial detention and eliminate the credit that persons would receive for pretrial detention." So in the past, what would happen is if a person was placed on pretrial detention, they could receive 2-for-1 credit, or even some cases 3-for-1 credit. What this means is that because pretrial detention conditions are much poorer compared to conditions for people who are in custody facilities because they've been sentenced to custody, such individuals on remand will be given 2 days credit for every 1 day that they serve on remand. So that means if they receive, let's say, a 3-month sentence, but they spent 1.5 months on pretrial detention or on remand, that means that their sentence is actually over if they receive 2-for-1 credit, because they'll get 1.5 months time served times 2 is 3 months, so they'd actually be released from custody. So Bill C-25 sought to get rid of this credit program. I've been fortunate to be part of a study where we interviewed young persons in custody both when they were sentenced during the YOA and when they were sentenced during the YCGA. And this allowed us to look at the profile of youth in custody under the YOA versus under the YCGA. We found some very important differences. First, Indigenous youth are much more likely to be found in custody under the YCJ compared to the YOA, so there's been a failure to address overrepresentation of Indigenous youth. We tend to find that under the YCJ, such youth have a much more serious risk factor profile. They're more likely to experience issues with substance abuse, more likely to have mental health problems, more likely to come from families with a wide range of their own mental health issues, substance use issues, and past involvement in criminal behavior. What we're also likely to see is that youth incarcerated under the YCJ have a higher rate of offending in adulthood compared to youth incarcerated during the YOA. And this kind of makes sense because of the risk factor profiles. And we'll end today's class with the discussion of different models of youth justice. In different countries, or even in different provinces, there can be different philosophies about how to approach youth justice. And in this class, we'll talk about 5 different models of youth justice. And I've shown a graph here that basically depicts a political spectrum or an ideological spectrum from the welfare approach to the crime control approach. Generally speaking, the ideological perspective on this graph reflects more left-wing views to more right-wing views. So starting from the welfare approach is more left-wing, and moving through to the crime control approach. In Canada, we have what we call a trifurcated approach. And that means, as I mentioned before under the YCGA, that there's a tendency to respond to different types of youth involved in crime depending on the level of severity of their offense. You'll also notice the province of Quebec flag featured here, and I've placed them separate from Canada, not because I'm suggesting that they should separate from Canada, but because they are able to kind of, under the Quebec Act, do their own thing, and they tend to follow a corporatist perspective. And I'll talk in detail about what each of these 5 different models actually mean. When we look back at the history of youth justice in Canada, we can distinguish the different justice acts according to a few models. So the JDA was strictly a welfare-based model, focusing on the rehabilitative needs of youth, even though, as I mentioned, maybe they didn't go about addressing these needs in the most effective or evidence-based way. They didn't really rely on empirical evidence. I would refer to the YOA as a failed modified justice model or a failed trifurcated model. I'll use the term trifurcated and modified justice model interchangeably, they're both basically meaning the same thing. The YCJ would be an example of a successful modified justice model, where it's called a modified justice model because it's sort of adaptable to the type of young person before the courts or before the justice system. These different youth justice models align with different theoretical perspectives on offending. The positivist or more empirically driven perspective that really emphasizes research tends to favor a welfare-based model because it emphasizes treatment and rehabilitative needs. While the JDA was influenced by the welfare type of model, try to keep the ideas about the welfare model and the JDA separate. The JDA failed, but it didn't fail because it was a welfare model. It failed because it did not do a good job of being a welfare model. Same thing with the YOA. It's not that the modified justice model doesn't work. It's that the YOA was an unsuccessful implementation of the modified justice model. The neoclassical school of thought, and remember that's where there's an acknowledgement of free will, rational choice, but also the idea of bounded rationality. The hedonistic drives of individuals vary in terms of their abilities to perform that rational calculus to figure out whether the costs outweigh the benefits. The crime control model is influenced by principles of deterrence and the idea that with punishment will protect society while also making individuals believe that it's not worth it to continue to offend in the future. I'll now go through key principles and ideas behind each of the 5 models, working left from right, beginning with the welfare model. Under the welfare model, sentences or dispositions are individualized, so the response by the justice system to the individual often is less to do with the actual offense committed and more to do with their underlying risk and protective factors and treatment needs. Because it might take varying lengths of time to rehabilitate an individual, this is why sentencing is indeterminate, and I would argue that this would be a fundamental flaw with the welfare model because it violates fundamental principles of justice. Under the welfare model, child care workers like social workers or probation officers are pivotal because it's their responsibility typically to identify the needs of youth and what their rehabilitation or their treatment will actually look like. And so the main task under this model is to identify or diagnose the underlying causes of crime and respond to those causes through successful treatment. Rather than view crime as solely a product of rational choice, the welfare model sees crime as pathologically determined. Some would argue that it's more genetic, some would argue that it's more environmental, other perspectives would talk about it as being a combination of each of those two, More contemporary welfare perspectives would say we need to look at crime as pathological, but focusing on both environment and genetics. The purpose of the justice system, the reason why we have a justice system, is not to punish individuals, but it's to identify the treatment needs of those individuals and respond to those individuals in ways that will promote rehabilitation. The easy way to think about the corporatist model is that it's basically exactly like the welfare model, but it tries to focus on rehabilitation outside of the purview of the state. So instead of using agents of the justice system like probation officers, we're focusing more on true childcare experts. In fact, in Quebec, criminology is a professional degree, just like engineering would be a professional degree in BC or any other province in Canada. In British Columbia, we don't think about criminology as a professional degree, but in Quebec, the idea was we will train undergrad students to be criminologists. That will be their profession. And rather than being agents of the justice system, they'll be professionals in criminology, adept at identifying the needs of the young person in conflict with the law. Like the welfare model, there will be an emphasis on rehabilitation, but it's rehabilitation through diversion, keeping the young person out of the formal justice system, because Quebec basically believed that government intervention was going to be bad. And the best way to avoid labeling effects was to have the young person diverted out of that formal justice system. Under the welfare model, the term pathological was used to describe why individuals offend, and I think this is fairly stigmatizing language, because pathology sounds like a disease, and crime isn't a disease. Crime could often be a product of inequity or of oppression or discrimination. I'm not saying that those are the only causes of crime, but there are a lot of causes of crime, and we need to recognize those. The corporatist model would talk about unsocialized youth as the main cause of crime. I don't know if this is the best term either. I think we need to recognize that an individual's environment can certainly influence criminal behavior, but it's not as if individuals were unsocialized or that their parents failed to socialize them. There can be a lot of other environmental factors at play, but still, like the welfare model, the focus here is on treatment and intervention. Those treatment and intervention strategies are sort of developed or designed to try and guide youth away from the formal justice system, as opposed to having formal justice system act as the intervener to treat unsocialized youth. Remember, the YCGA was especially complex, but it was successful because it had that hierarchy of principles. The same thing here with the modified justice model, which was really influential in creating the YCGA. It says we need a lot of different elements. We need to have things like due process, determinate sentences, but it also emphasizes things like informality. And so students might think, well, this sounds contradictory. How can we emphasize procedural justice, which is very formal, and informality, which obviously is not formal? The way that the modified justice model balances these sort of competing aims is by identifying, okay, for non-serious offending, we will focus on informality. For more serious or moderate offending, we will emphasize due process and these sort of procedural safeguards to make sure that individuals' rights are not being violated. The added complexity of the modified justice model means that lawyers become key, because we need the lawyers to be able to interpret how the act should be applied. And we also need childcare experts, but especially clinicians, to help identify which youth may be more serious in their pattern of offending and therefore require more of a focus on protection of the public and procedural safeguards, and which individuals would be better served through a community-based response, more informal and kept out of the official justice system. So we see that blend of diagnosing the problem that's common amongst the welfare perspective, but also punishment, which we see as germane to both the justice model and the crime control model. The modified justice model recognizes that youth have a diminished responsibility because their brains have not fully developed, their identities and personalities are still developing, and so they are held to a lower standard of blame. The idea is to sanction the behavior but treat the individual, not sanction the individual because of the belief that deterrence will not necessarily be all that effective. And in doing all of this, it's important to respect the youth's individual rights under the law. Now onto the justice system model, which basically excludes the welfare component that we see in the modified justice model. So The justice model is just sort of like a more narrow version of the modified justice model, and it's basically entirely focusing on due process, emphasizing determinate sentences, focusing on offenses and not status offenses or behaviors for which an adult would not be penalized, and using the least restrictive measures, because justice model doesn't mean being punitive, it means being proportionate to the harm done. Not surprisingly, the key people under the justice model will be lawyers, because it will be their job to make sure that these procedural safeguards are being respected. The lawyer is there to look out for the legal rights of the young person. The lawyer under the JDA, for example, might be more looking at working with the probation officer to develop treatment and intervention strategies. The lawyer is more, under the justice model, is more about making sure that the young person has the right to a fair trial and so on. The justice model does take into consideration deterrence, so it does emphasize the punishment of offenders. It does believe that deterrence will work. And while it believes that deterrence will work, it also acknowledges that youth are less responsible for their behavior compared to adults, and that needs to be taken into consideration when considering the proportionality of the offense or the sentence to the offense. There is not much of an emphasis or consideration for the individual level risk factors that might be influencing the young person to engage in the crime. The focus is more so on the offense that the young person has perpetrated and figuring out what have other people who've committed the same or similar offense and in similar circumstances received as a sentence. When looking at the YCJA, I would say that we can see evidence of JDA-based principles focusing on the welfare and the rehabilitative needs of individuals. Also can see some justice-based principles by focusing on individual rights. Remember, doing things like getting rid of presumptive sentences, no longer transferring youth automatically to adult court. These are all procedural fairness foci. Is that a word? Foci. But it's not as if the YCJ doesn't also have sections that call for more punitive responses to youth who have perpetrated especially serious offenses. Such youth can be likely to receive an adult custody sentence, which is more in line with the crime control model, which emphasizes the protection of the public through the punishment of the young person. Lastly, I'll talk about the crime control model. And the crime control model isn't always just like eye for eye, send everyone to jail, don't worry about whether they did the crime or not. It's more about also taking into consideration the rule of law, following due process, but also giving judges discretion to make an example out of a person if they believe that they've been involved in a particularly serious offense. Because the crime control model believes that deterrence works, they tend to include in their legislation status offenses because they believe that these status offenses are stepping stones towards more serious behavior. And so if the individual gets punished severely for these status offenses, that will make them not want to engage in more serious offenses in the future. And I think this is probably not the right approach. And I think there's some fairly solid empirical evidence that will show that negative interactions between the young person and the justice system at a particularly young age can only serve to further that young person's involvement in the justice system. Lawyers are important, again, because there's an emphasis on due process. Justice system stakeholders, especially victim rights advocates, can also be key because they will lobby the government or lobby judges to become more strict or more punitive. And so the philosophy behind this model is to incarcerate and punish individuals to protect society, deter other members of society from wanting to offend. That would be general deterrence. And then deterring the individual from wanting to commit offenses in the future because they'll be sent back to jail, so that would be specific deterrence. The crime control model emphasizes responsibility and accountability, and those might seem like perfectly reasonable expectations and principles, but I think what's missing from this model is an understanding that different people come from different backgrounds and that can impact the level of responsibility or their ability to be accountable for their own actions. For example, I've interviewed kids with fetal alcohol spectrum disorder. To think that that individual should be held to the same level of responsibility or accountability as someone like myself, I think is ridiculous. These individuals did not do anything that gave them FASD. They've been a horrible victim of circumstance. And the symptoms of FASD make it very difficult for such individuals to see the consequences of their actions. This is why some principles of the welfare model are useful, because it helps recognize that individuals coming from different backgrounds are not all going to be equally responsible for their behavior. This model emphasizes that we have to protect society, and the way to do that is through retribution, this eye for an eye form of justice, which will deter the individual as well as society more broadly. On the topic of society more broadly, it's thought that this will help by punishing individuals, help maintain order. When we talked week 2 about the social contract, Hobbes' idea that people are naturally going to be bad and we need this social structure and these social agreements to make sure we don't harm one another. The crime control model kind of cranks the intensity of this notion up to 11 and says that we really need to come down hard on persons that violate the social contract to send a message to others that violating the social contract is not okay. I won't talk about this further. I'm just going to put this slide up here for your own reference to kind of summarize all the different points that I've mentioned about who the key players are within these different models of youth justice, their key principles, their key goals, and so on. So thanks everyone for paying attention to another week, and we'll see you in the discussion sections for this week's tutorial groups.